Okay, busia for min church obi bia sama obi bia kwa ba bia memfambra enkasa TV nkasa kase eboso na edru sisi busia for some amuni say minya tena sisi dia na chise me de update nkwa na ebe news enkan si okwa na me de ebe som ahwefo ewo YouTube channel no so na enani dey di count me me so be subscribe to my channel be like you do adwin che so ebe go comment section abusia for ense bi ekoso the four corners of Ghana busiafo ne nsɛm no mempɛ sɛ mɛka sɛ bebree no mu nkotie nsɛm mu nkyerɛmu yɛkɔba a ɛba abɛtoa so.
The special prosecutor will issue directives and further action to the matter in due course. Now we're moving to live to bring you the press release that is happening right now.
To induce or reward improper favor by government official one in respect of the purchase of 3 C-295 military transport aircraft. The referral also related that indeed, out of the 5 million euros promised to intermediary 5, 3.8 million euros was paid between March 2012 and February 2014. Further, the referral indicated that similar conclusions had been reached by investigative and judicial authorities in the United States in the case of United States of America against Airbus SE. The referral requested that given the implications of the judgment, the OSP may collaborate with its United Kingdom and other foreign counterparts to conduct a prompt inquiry to determine the complicity or otherwise of any Ghanaian government official, past or present, involved in the scandal, and to take the necessary legal action against such official as required by Ghanaian law. Now I'll go to the investigation and judicial pronouncements by the relevant foreign authorities because that sets the background for my briefing today. On 31 January 2020, 3 courts, one each in the United States of America, the United Kingdom, and France, simultaneously delivered similar decisions containing agreed outcomes, variously described as consent agreement, deferred prosecution agreement, or judicial public interest agreements, depending on the jurisdiction, between Airbus SE and the relevant authorities in the 3 jurisdictions. The apparently coordinated judicial decisions impose global financial sanctions in excess of 3.9 billion euros on Airbus. The agreed judicial decisions were the outcome of joint investigations carried out by the Serious Fraud Office of the United Kingdom and the French Parquet National Financier, PNF, and a parallel investigation conducted by the United States Department of Justice, DOJ, and the United States Department of State, DOS, in respect of alleged bribery and corruption and violations of the United States International Traffic in Arms Regulations, ITAR, involving Airbus in Malaysia, Sri Lanka, Taiwan, Indonesia, China, Colombia, Nepal, South Korea, the United Arab Emirates, Saudi Arabia, Taiwan, Russia, and Ghana. The alleged bribery offenses of Airbus in respect of Ghana was investigated by the SFO in the United Kingdom, while the DOJ in America investigated violations by Airbus of parts of the US ITAR in the context of the alleged bribery offenses in relation to Ghana. Therefore, as I said, the judicial decisions of the United Kingdom and the United States affected Ghana. Consequently, investigations carried out by the SFO and DOJ and the decisions of the 2 courts bear on the investigation by the OSP and thus require recourse and in some detail. Bear with me. This is important. First, the United Kingdom. It is well known that on 31 January 2020, the President of the Queen's Bench Division, the Right Honourable Dame Victoria Sharp, sitting in the Crown Court at Southwark, delivered a final declaration and order in respect of a deferred prosecution agreement, DPA, between the SFO and Airbus in the case of Director of the Serious Fraud Office against Airbus. This was based on investigation conducted by the SFO in respect of Malaysia, Sri Lanka, Taiwan, and Ghana, which was held to demonstrate that in order to increase sales, persons who performed services for and on behalf of Airbus offered, promised, or gave financial advantages to others intending to obtain or retain business, or an advantage in the conduct of business for Airbus, and that those financial advantages were intended to reward such improper performance, and further that Airbus did not prevent or have in place at the material times adequate procedures designed to prevent those persons associated with Airbus from carrying out such conduct. In respect of Ghana, Airbus was charged with the offense of failure of a commercial organization to prevent bribery, contrary to Section 7 of the Bribery Act 2010 of the UK. The particulars of offense stated that between 1 July 2011 and 1 June 2015, Airbus failed to prevent persons associated with Airbus from bribing others concerned with the purchase of military transport aircraft by the government of Ghana, where the said bribery was intended to obtain or retain business or advantage in the conduct of business for Airbus. The accompanying statement of facts summarized by the SFO's position is that between 2009 and 2015, an Airbus defense company engaged intermediary 5, who was stated as having no experience in the aviation sector, a national of the UK but born in Ghana, and a close relative of a high-ranking elected Ghanaian government official described as Government Official 1, as its business partner in respect of the proposed sale of 3 aircraft to the government of Ghana. A number of Airbus employees knew that intermediary 5, who was a close relative of Government Official 1, a key decision maker in respect of the sales. A number of Airbus employees made or promised success-based commission payments of approximately 5 million euros to intermediary 5. False documentation were then created by or with the agreement of Airbus employees in order to support and disguise these payments. The payments were intended to induce or reward improper favor by Government Official 1 toward Airbus. Intermediary 5 was assisted in his work for Airbus by 2 other nationals of the UK, Intermediary 6, a good friend of Intermediary 5, and a UK television actor and film director, and Intermediary 7, a former UK television actor. Contact between Airbus and the government of Ghana about aircraft sales began in June 2009 following an expression of interest by the government of Ghana. By August 2009, employee 15 reported that he was in contact with Government Official 1 and his team. On 7 December 2009, intermediaries 5 and 6 incorporated a company, Company D, in Ghana for this purpose. A company of the same name was incorporated in the UK in February 2010. Company D was a corporate vehicle through which Intermediary 5 and his associates provided services to Airbus. In December 2010, Airbus employee 16 was made aware that intermediaries 5 and 6 were or had recently been working for Government Official 1 and or the government of Ghana. The Airbus campaigns in Ghana culminated in the sale of 3 C-295 military transport aircraft by Airbus to the government of Ghana. In respect of the first campaign for the aircraft, Airbus paid 3.9 million euros to a third-party company, Intermediary 8, between March 2012 and February 2014. Intermediary 8 in turn paid 3.8 million euros to Company D. In respect of the second campaign for the sale of 1 C-295, Intermediary 5 or Company D were promised approximately 1.6 million euros. The promised amount was not paid. From 2009, Intermediary 5 and his associates worked on the sales to the government of Ghana without any written consultant agreement.